What's up, everybody? And welcome back in as we are breaking down a motion to recuse the judge in the YSL trial in Georgia. After all the shenanigans going on, one of the lawyers has filed a very detailed motion to recuse that judge where we find out details of what happened in this secret ex parte meeting with the judge, the prosecutor, and a witness that was already sworn in. I'm going to bring my dad on. We're going to talk about what's unusual about this, what this says about the judge and the system that's going on there, and what we think is going to happen next. All right, so we are going to start with the motion itself, which is a motion to recuse the chief judge. And by the way, while we're talking about this, we might as well mention this witness, Mr. Copeland, has been testifying. It has been wild. He has been telling them that he's just saying yes to get it over with. He has been refusing to answer some of their questions. He has been doing all sorts of things that you hate to see as a lawyer on the stand. And that's going to give a little bit of context. They have continued with the trial. They have a lot of breaks, which is important as we dig into this. But anything you want to mention as to what's going on in the trial before we read this?
Well, he doesn't remember a lot.
Yeah.
It's interesting. They've given this guy immunity. Normally, when we would give somebody immunity at the U.S. Attorney's Office, we know what he's going to say before we give him immunity because, we don't want to give him immunity and him stand up there and say that, he murdered 50 people. So we make sure we know what he's going to say, make sure it's valuable, make sure it's worth giving him immunity. In this case, they gave this guy immunity, and they obviously do not know what he's going to say. And he has, in key areas that I think are very important for the prosecutors, he doesn't remember. So he's a bad witness.
Yeah. And I think it shows just how important he is to the prosecutor's case. They are willing to give basically anything to get this guy on the stand to say what they need him to say, which we're going to get through that today. I just sent you a text if you want to check your phone. But let's get into this motion here. The defendant, Mr. DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to recuse Chief Judge Ural Glanville from continuing to preside over the present case and requests that the present trial be temporarily halted until the present motion is heard by another judge of this superior court consistent with the uniform rules of the superior courts of the state of Georgia, stating the following. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that a court should be fair and impartial. The present case involves a 65-count RICO indictment against 28 individuals. Jury selection in this case began in January of 23, with the jury trial beginning in November of 23. Given that the state has presented less than half of its current witness list, and again, that it started in November of 23, so that's 7 months ago, and they've only presented half of their witness list. Now, sometimes they don't present all the witness list, but that is saying something. The trial should last well into 2025. The 6 defendants presently on trial, 6 out of 28, including Mr. Kendrick, have been denied bond and incarcerated for over 2 years. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. That's the witness we referenced off the jump. On Friday, June 7th, 2024, Kenneth Copeland was sworn in. Despite being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, Copeland refused to testify on that day. We watched a lot of that together, and that's what spun into Steele ending up finding about this ex parte meeting that happened afterwards and eventually thrown in jail. Copeland was ordered to be incarcerated by Chief Judge Glanville on that date, and Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30, where Copeland would announce whether or not he was prepared to testify. On June 10th, all defense counsel were present in Fulton County Courthouse around 8:30, admitted entrance into courtroom 1C and seated by 9 a.m. Defense counsel waited and waited. Between 11 and 11:30, Glanville took the bench and announced that Copeland was prepared to testify. I mean, that should have been a surprise to all of them because they didn't know what he was going to do. They were supposed to be there at 8:30 and nobody really shows up till 11:30. Brian Steele, counsel for Mr. Williams, inquired with the court as to the delay to the chief judge taking the bench. His inquiry was not accepted. What do you think about that? I mean, that's a pretty big deal right there that they asked about it and the judge would not even take it under advisement at that point.
Well, I mean, it's obviously he didn't want him to know. And he thought they wouldn't find out. And wrong he was. But he thought they wouldn't find out, so he figured he could just brush it off and move on.
Unknown to any member of defense counsel during the waiting period in the morning upon information and belief. You're going to see upon information and belief a lot. That's like them saying, I know, but I can't tell you how I know, or I think I know, but I'm not sure.
Well, it's also a way of saying this is not my personal knowledge, but I got it from somewhere else.
Right.
Right.
An ex parte meeting was held in Chief Judge Glanville's chambers on June 10th, 2024. Among Chief Judge Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. And he's citing the affidavit, which we'll read at the end. No members of defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. We'll get the definition of that later. Upon information and belief, neither Judge Glanville nor any member of the court staff nor the Fulton County DA office made any member of the defense counsel of all the defendants aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. Copeland briefly testified prior to a lunch recess. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and made aware of at least some of the content and subject matter of the ex parte meeting. So these are only some of the details, and they were made aware, but they're not telling us how they were made aware. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in the chambers of Chief Judge Glanville. So these are the highlights, but like I said, we're going to read the whole affidavit at the end. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Why is that important if they found out right before he took the stand?
Well, because they want to cross-examine him.
The defense wants to cross-examine him.
Right, and they don't have this. They're not going to have this information to cross-examine him. Although that's changed.
Well, not just that, but the regardless of what the defense wants to do, if the state knows it, they should have been able to put him on. And so, what changed, and how did that change? I think that's the important part. I'm not going to read upon information and belief every time. Copeland stated that he would sit in jail for 2 years rather than testify. Chief Judge Glanville informed Copeland that Glanville would keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants in trial now. So until 2025, which is this whole trial, then when they can try the remainder, whoever else ends up going to trial, he's just going to have to sit there the whole time. That's the threat.
Let me stop for a second.
Okay.
The next ones you're going to read, the one thing I was looking for was to see whether or not those statements by ADA Love or the other ADA were made in the presence of the judge. They don't say that they were made in the presence of the judge. I think that was interesting, and I don't know if it's on purpose or not.
Well, they don't say they weren't, and they did say among the people there were the judge, the ADAs, and the witness. So if he wasn't, if something changed, I would think they would put that in there, but I don't know. ADA Love and Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Chief Judge Glanville, in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. So at first he pled the Fifth, which is important because then they can't call him. Number 2, he gets these threats. Number 3, he changes his mind. Do you consider that coercive, or is that appropriate for a judge to do?
That's coercive. And not only is it coercive, it is, there was no reason for the defense not to be there.
And that's what I was going to say. So would you consider it coercive if the defense was there, or is that appropriate pressure put on a judge for somebody to testify?
Well, if they were there, they would have the opportunity to object to the way the judge was conducting it, and they could have made a record. But because they didn't do that, there is no record, and they have no chance to object to how Granville did it. They could have sat there silent. If they would have done that, then they would have waived their right to object, and therefore they couldn't object because they didn't say anything. But because they weren't there, they never had the opportunity to object or to agree with Granville doing this.
Glanville, yeah. And the important thing there is they have to have the opportunity to fight this, to object, to dig in, and to see, because I think there is an appropriate way to do this, to say, that's fine, sir, if you want to be incarcerated, you've said that, but just so you know, it's not 2 years. I don't know where you got that number. It's just until all the defendants that you might testify to finish testifying. So if that's what you want to do, that's fine. And maybe it's not coercive, but then there's obviously a coercive way to do that. And the way we protect that process is with criminal defense attorneys there able to object and make sure the judge is doing it appropriately.
Right. Like we'll go to the next bullet point and you'll see what he did. And that's not necessarily wrong for the judge to give him a copy of the statute.
Depending on how he does it, right? And that's the point.
It's wrong with the defense not being there.
Right.
Flat out wrong, never right. But it could be if the defense agreed to it.
And you've got the DA and you've got the judge basically pushing a witness to testify for the DA. That's problematic. It looks like they're teaming up to force this witness to testify and be a key witness for the state against the defense. And the defense isn't even there to fight.
That's the biggest part of the impropriety of this, or the appearance of the impropriety, is the fact that those two are working together for a witness for the state.
That's what it looks like, at least. I mean, whether or not that's true, I don't know, but that's surely what it looks like. Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Also a problem because they can't put a witness up that they know is going to lie. That would be unethical. In response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. That's problematic.
That's the part I was talking about before. Did she say that in front of the judge? Because that would be something if the judge actually heard an ADA say that.
Because no lawyer can put a witness on the stand knowing that they're going to lie. That's committing a fraud on the court. And that's like rules of professional responsibility 101 that you can't do that as a trial lawyer.
It's a crime. I mean, they're conspiring with a witness to commit perjury. They're committing a crime.
And the problem with that is, like, yes, the ADA can choose who to prosecute and who not to prosecute. That's fine. But it doesn't matter. Like, if I'm a lawyer and I'm not the district attorney, I can't file criminal charges. I still can't put a witness up there to lie, and neither can they. Sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas Jr. In response to sworn witness Copeland stating that, ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. So why would she do that? Well, the answer is that's bad for their case. So basically, she's threatening to prosecute him if he testifies to something bad for their case. But if he testifies to something good for their case, even if he lies, she won't prosecute him.
Right. Part of the racketeering enterprise acts was this Thomas murder. So they had to have the other people involved in that Thomas murder because that's part of their proof in the racketeering or the homicide.
But the really incredibly important part of this is that the judge is putting pressure on the witness to testify. The state is putting pressure, giving him immunity, number one, which can be appropriate, but then telling him they're not going to prosecute him for perjury if he testifies to something that's a lie, unless it's bad for them, a lie that, or something that they think is a lie that's bad for them, then they will prosecute for perjury. It's just, it's horrible.
This is so incredible.
It's horrible. If this is true, and we don't have the transcripts, we don't have the recordings, assuming that the defense is going to get that so they can confirm all of this. If this is true, this is absolute corruption. Do you think this is enough for a mistrial just right here?
Yes, it's enough for mistrial. It's enough for somebody to investigate the Fulton County State Attorney's Office. And if this, in fact, happened in chambers, in the presence of that judge, there should be a lot more investigation going on, because that's a corrupt system from the bottom to the top.
And it sucks because this case has been going on so long. I get that the judge is probably so annoyed. It's been difficult. And this is why when people wonder, why do we sever cases? It's really hard to try 6 people at the same time, 6 different defense attorneys, RICO charges, a ton of moving parts, a ton of witnesses, months and months and months. I mean, these are the hardest of cases. What a waste of tax dollars if this is a mistrial and they have to do this all over again.
And this trial, if you look through, this trial has got a history of being chaos. About every turn, things have gone wrong. And you have defendants accused of passing drugs to each other during the trial. You have a defendant being stabbed in the jail during the course of the trial. You have drug arrests of lawyers during the course of the trial. I mean, come on, how many things can happen in one trial?
They must have had 100 motions for mistrial throughout the trial too. I mean, it's been crazy. During court on the afternoon of June 10th, when one or more of the above allegations were presented to the court by Attorney Steele, Chief Judge denied that one or more of the events above relayed to him were accurate. Okay. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, would warrant the assigned judge's recusal from the case.
Can I interrupt just for
Yes.
1 second? Okay. I read the Mundy case.
Okay.
And in the Mundy case, the judge did not recuse himself and did not make those determinations. But in the Mundy case, the court said it was harmless error, and they did not reverse the case. So they went against the defendants, even though the judge didn't do these things. So it's kind of funny. They were citing a case that the defense lost.
So it almost feels like it wouldn't even help them what this case stands for.
Well, it's not as strong as they would like it to be.
The present motion for recusal is being timely submitted to the court. The present motion is being filed and presented in the court in a timely manner. Uniform Superior Court Rule 25 governs motions for recusal. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge not less than 5 days after the affiant learns of the alleged grounds for disqualification. Such submission shall be submitted not later than 10 days prior to the hearing or trial, which is the subject of recusal, unless good cause is shown for failure to meet the time requirements. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident requiring recusal to the filing of the present motion is good cause. And then the footnote there is USCR 25.1 also reads, in no event shall the motion be allowed to delay the trial or proceeding. And this motion will address the internal conflict between USCR 25.1 and 25.3 in a later portion. So they're saying you have to stop what you're doing, but then you can't stop the trial. They'll deal with that later. Present motion includes a sufficient affidavit demonstrating the need for recusal, an accompanying affidavit by Douglas Weinstein, who's also the lawyer filing this motion, with evidence for recusal, has been filed and is now presented, which fully asserts facts upon which this motion is founded as required by USCR 25.1. A review of the Weinstein affidavit shows that it clearly states facts and reasons for the belief that bias or prejudice exists, as is required by USCR 25.2. The Weinstein affidavit is specific with respect to time, place, persons, and circumstances which demonstrate bias in favor of the state that prevents impartiality in the present case, as required by 25.2. The particulars of the Weinstein affidavit are provided above and need not be presented again here in detail, but lays out alleged actions of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in chambers. Recusal is warranted based on the facts alleged in the Weinstein affidavit. The facts alleged in the Weinstein affidavit must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein upon information and belief, we're not saying how, detail the holding of an improper ex parte hearing, and we're going to read that footnote about why it's improper, conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and fair trial. The ex parte hearing with sworn witness Copeland was in violation of at least section 2.9 of the Georgia Code of Judicial Conduct. I'm going to finish this paragraph, then we'll read the footnote, which assures every person, including persons such as Mr. Kendrick, of a fair hearing. Ex parte communication are presumed to have been an error. So here we go. Georgia Code of Judicial Conduct 2.9. Assuring fair hearings and averting ex parte communications provides: A, judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. So we're going to read some exceptions, but again, as lawyers, we know you cannot do this. I can't just send an email to a judge. I can't just call a judge on the phone, no matter how good of friends I am with them, and say, hey, let me tell you about the Smith case. We're going to file these motions, or I may need some help pressing this witness when we do call them. You can't do that. You just can't do that. Okay, exceptions. Where circumstances require, ex parte communications are authorized for scheduling, admin purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. I mean, is that spot on to you?
Yes,
I mean, like
it is.
that's a it's almost like a procedural, substantive, and strategic advantage. It's almost all three that they get from forcing this witness and putting all the pressure on this witness to testify, but not just to testify the way they want him to testify. I mean, that's crazy. All right, B, the judge makes provision promptly to notify all parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Huh. That sounds exactly like what the defense lawyers were asking for in this case, right?
Exactly what the judge didn't do.
All right, and then section 2, judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afforded the parties reasonable opportunity to respond. It's not what happened here, but they still didn't. Like, the very important part of this section that you can all see in here is give the parties an opportunity to respond and to know what's going on. Notify them. Number 3, judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. Or 4, judges may, with consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. So you notice a common theme there, whether it's to mediate or talk to an expert or talk to staff or whatever it may be. The parties all must be notified and have an opportunity to say their piece and make a record, right?
Right.
I mean, that's like the important part of this rule. Wouldn't you agree? I mean, what are your thoughts after reading it just right there in black and white?
Well, I tell you what, it's better than the Florida rule. It goes into more detail, more requirements for the judge, but the sad thing for this case is it's right on. I mean, this is the chief judge. If the chief judge is not aware of exactly what that rule says, and you've got to wonder about the system in Fulton County.
Well, it definitely seems like he doesn't know. I mean, he definitely seemed like he didn't know the difference between civil and criminal contempt either.
No, he didn't. He didn't.
Right? I mean, that's something that came out when Steele's lawyers were in the courtroom.
Right.
All right, let's keep going here. Rule 211A, the revised Georgia Code of Judicial Conduct, says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than from the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify on behalf of the state, either in or out of the presence of the jury. As the Georgia Supreme Court wrote, we need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has personal bias or prejudice concerning a party or party's lawyer. Defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. We're going to read what a critical stage is the next footnote. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Glanville, the state, sworn witness Copeland, was to harass and intimidate the sworn witness into testifying. Given the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient, and that recusal would be authorized under the alleged facts. Another judge should be assigned to hear the motion to recuse. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all the requirements, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion to recuse, Mr. Kendrick requests that the court make specific factual findings and submit that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial due to the ongoing bias the court has evidenced in the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment, should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review. I'm going to ask you a question, but I want to read this footnote here real quick because this is the end of it. A critical stage is one in which a defendant's rights may be lost, defense is waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Would you call this a critical stage?
Yes, I would call it a critical stage, and I would rely on the last phrase, one in which the outcome of the case is substantially affected in some other way. This is a key witness, whether he testifies or doesn't testify, whether you can cross-examine him based on his refusal to testify. Those are things that are critical, and I mean, it falls right into the definition. It makes a difference.
And defendant's rights may be lost, the right to cross-examine, right? I mean, yes. That's what you always bring up. So, all right, footnote 5. During the course of a trial, there appears to be an internal inconsistency between 25.1 and 25.3. So this is like halt everything, but we can't stop the trial. How do we deal with that? Mr. Kendrick submits that the court can reconcile the intent of these rules by briefly hearing the motion to determine the timelines and sufficiency of the Weinstein affidavit and make the necessary determination without delaying the trial. The court regularly hears motions during the course of the present trial, and this motion is no different. He's heard a million motions. Let's just do one more is basically what the defense says. Not a huge deal there. So before we read the affidavit, my main question to you is, do you think there's any way to continue this trial if, like, Judge Glanville recused himself? Is that something that's possible?
Yeah, absolutely. I think a mistrial is certainly possible. I think that I just don't see how he doesn't have another judge review this motion. I just don't see how he can sit there and deny this motion on its own, because I think any reasonable person, again, that's the standard, it's not the lawyers. Any reasonable person from the outside is going to take a look at these facts and say, oh my gosh, this is terrible. And that's enough. Now, the facts don't even have to be true. They can be total lies. But the fact is that those facts raise enough of an issue for a reasonable person that they are going to say to themselves, there's something here and we got to take a look at it.
So, and just to clarify, like, lawyers can't lie in affidavits, obviously, and this is from a lawyer. Like, you have to have a good faith basis for it, and he says he does. But the point and the illustration of your point is they are taken to be true, regardless of how untrue they may seem. Right. They are taken to be true for purposes of this.
It's obvious this lawyer wasn't there, so he is repeating what somebody else is telling him. So he's being truthful because he has a basis for the belief, and that is there is a person that's saying this, so there's a basis. And all I'm saying is that even if that person were lying, there's still enough of a basis here, because you've got to say it's true, and then another judge would have a hearing to make a determination whether it's true or false.
And Judge Glanville, in some of the videos we played last time, said, I know somebody must have been in there and was parroting this to you, or you were eavesdropping, which I think gives a little bit of credence to some of what these defense attorneys are saying. Because he's not saying you guys weren't there. Somebody lied to you. That didn't happen. It seems like they're spot on, and that's what's ticking him off.
Well, there's something really funny going on. Let's go through. You want to go through the affidavit first, and then we'll talk about that?
Sure. Let's go through the affidavit first, then we'll talk about what's going on. So, sworn witness Kenneth Copeland had been held in civil contempt of court on June 7th for refusing to testify on the date after being given a grant of immunity by Glanville, who's presiding over the case. He instructed the witness and all parties on June 7th that Copeland would be jailed and returned on June 10th. Upon information and belief, defense counsel were all present at the courthouse at 8:30. They all walked in at 9. Then they have this ex parte meeting that the defense attorneys didn't know about. Glanville was there, ADA Love, Hilton, and members of Fulton County DA's office was there, as well as Copeland and his attorney. No member of the defense was present there. Upon information and belief, no member of the defense was aware that the meeting was happening. Sometime between 11 and 11:30, he takes the bench and announces Copeland will testify. So magic. How did that happen? Well, we're going to find out. At that time, Steele, counsel Mr. Williams, inquired to the court, what the heck's happening? And that inquiry was not accepted. Copeland briefly testified. Then the ex parte meeting, the morning of June 10th, Copeland announced that he would invoke his Fifth Amendment. So this is what happened in the ex parte meeting. He would invoke his Fifth Amendment right. He stated that he would sit in jail for 2 years rather than testify. Glanville informed Copeland that he could keep him incarcerated until additional defendants were tried, not just these 6. ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Glanville took coercive actions in conjunction with one or more of the attorneys from the DA's office. So then Copeland stated at the ex parte meeting that he would testify. Glanville also presented Copeland with the printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. In Glanville's chambers, Copeland stated to ADA Hilton that if called, he would lie. ADA Hilton stated she would not prosecute him if he were to lie on the stand. Then he said he would say he committed the homicide against Donovan Thomas. And Hilton said she would prosecute him for perjury if he testified that he committed that crime. And when one or more of the above allegations were presented to the court, Glanville denied that one or more of the events above relayed to him were accurate. Okay? So that's just the full affidavit there. So what were you going to say?
All right. You step back and you kind of look at a big picture on this. First off, remember what Steele said in the hearing where he was held in contempt, where he made allegations about what happened in that meeting. He never mentioned the ADA, the perjury, that there's a lot of facts in this affidavit that Steele did not mention. So you have to ask yourself, were there additional conversations after Steele was held in contempt that revealed other things that went on in this meeting? So that things that Steele didn't know when he made his original motion, because I'm sure he would have mentioned this in his original. I mean, this is dynamite. He would have mentioned this in his original motion for mistrial.
Well, if you remember, the judge was trying to make sure he didn't say facts, and he was trying to shut him down and stop him and saying, before we get into any of the facts, tell me who told you.
Right, but Steele, he wasn't very successful. Steele still was making his record as to what he heard. And
I feel like when I heard it the first time that he had more information than he was sharing personally. That was my feeling on it.
See, I think he would have blurted this out if he had it. So I'm of the opinion that these were ongoing conversations that they were having with somebody. And they got more information after Steele was held in contempt. Because remember that Steele's conversation, that happened right after the meeting in chambers. There wasn't a lot of time between the meeting in chambers ending and Steele making his motion. So maybe they didn't have a full debrief of whoever it is they were talking to. Also remember, this judge has issued an order to show cause that everybody that was at that meeting, I think it's the 25th, everybody at that meeting is going to have to show cause, and the judge is going to question each one of them about their conversations with law enforcement. I mean, with the defense lawyers. And again, keeping things in perspective, if you remember, there was a gentleman that represented Copeland initially. But then when Copeland fired his lawyer, that gentleman wasn't there anymore. There was a lady there. What happened was the gentleman had tickets that he couldn't get a refund on. So he took a flight and went on vacation and left the I guess the lady his partner, I don't know what the relationship is, to show up in court to get fired. So the lawyer for Copeland, the gentleman that was at the meeting in chambers, was on an airplane when the issue happened that that lawyer was fired. So there's a lot of things going on here. It's going to be interesting to find out, what happened. And during the course of the court hearing, and it's hard to keep the lawyer's name straight, but one of the defense lawyers moved for Brady information. When he I don't know if you saw that or not, but when he moved for his Brady information. And by Brady, I think a lot of your listeners know from other cases that if the prosecution knows of something that goes to the innocence of a defendant, they are required to tell that defendant if it's exculpatory. But in this case, when they asked for Brady, they were also challenging the judge, because Brady information can come out of that ex parte hearing, things that were said, and there was a transcript. The judge admitted on the bench he was reviewing that transcript, and that he would turn over or reveal to the defense anything the judge felt was necessary before the defense cross-examined Copeland.
Seems like a lot of this might be relevant to Brady, right?
Yes.
Even if he said he was going to lie,
many of it
I mean, if he said he committed that homicide, that's Brady. That's like the definition of Brady.
Or how about the fact that, isn't it true the prosecution said you can lie and they wouldn't prosecute you? That sounds like Brady information to me.
Exactly.
I mean,
it's crazy.
Yeah, it is. It's totally insane. And then the prosecutor, Miss Love, also stood up and said that they would provide any Brady information if they knew anything that was inconsistent with Copeland's testimony. So you've got the prosecutor say, oh, no, we'll turn it over. So everybody in that courtroom, the prosecutor and the judge, and Copeland, all knew what happened. The only people in the dark are the people that have the constitutional right to a defense, and that's the defense.
And that's literally, we write all these rules to make sure that doesn't happen. The courtroom is supposed to be the only level playing field and fair ground that we have. And when stuff like this happens, that goes away. From my perspective, and I've watched probably 30% of this trial, I'd say, over the last 7 months, because I've done clips here and there. I've watched a bunch of reviews. I watched a few full days. There's no way that this has been a fair trial to these defendants, regardless of what you think about them, regardless of what you think about the defense lawyers, who some people always hate. There's no way you can look at this and say this has been a fair trial. Just no way.
Absolutely not. Too much has happened in this trial. It really needs to be a mistrial. They need to just start. I realize costs a lot of money, and judges think about how much money trials come. It's a 6 month trial. I mean, think 6 months, more than 6 months. Think about the attorney's fees. Think about the court personnel. Think about the state attorney's office. Think about all of the things, just the air conditioning, the building, all the maintenance, all that stuff goes into this.
The three hots and a cot from the lawyer they threw in jail.
Yeah, but he's okay. I mean, he wasn't.
I'm just kidding. But I'm saying,
sharing a cell with that client is smart. It was good tactics, but it was also, he's probably safer there than he is walking the streets at night in Atlanta.
It's just, I mean, it's just crazy. This trial it's literally like a circus. I mean, it feels like this is embarrassing to me for the judicial system, in my opinion. This is not what it's supposed to look like. But again, so many people are like, oh, this judge seems really prosecution heavy and favors the prosecution. It's like, that's most judges. And it's been highlighted in a couple cases. And this is one where it's like, this is horrible. Like, this is absolutely horribly corrupt.
Over the top, most
if
judges
it's true.
are prosecution oriented. I mean,
if it's
most
true.
judges are prosecution oriented. I mean, we know that. We know that going into a trial. But we just hope, even though you're prosecution oriented, just give me a fair trial. Let me try my case. This judge is doing everything he can so these guys can't try their case.
And that's why a lot of times we try to just judge, just step aside for a second. Let us do our thing. Let us talk to the jury, because, a lot of jurors come in and just think people are automatically, guilty or believe cops or whatever. But lawyers feel like they can talk to jurors. They can explain it to them, use common sense. Let's do this right. And even if a judge is against you, sometimes you can still get through. But when they take it to this level, there's a line, and it's been crossed in this case.
Yeah, and I would like to also say one thing for your listeners, that I am using the mic you bought me.
You're a little far away, so hopefully it's not too echoey. We'll see what people say. But we're working on it. We're working on the logistics here. But all right, that's all we got. You got anything else?
No, that's it.
All right, cool.
That's caught up. We're caught up.
Ish. I mean, more stuff has happened, but if you guys have questions, let me know in the comments. If you want us to continue breaking this down, let us know by hitting the like button and subscribing to the page. Till next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.